So the Manhattan DA's office on Luigi Mangione's case filed a letter today with the court in response to the accusation that they put forth a fake subpoena to get Luigi Mangione's health information from Aetna, and that they weren't entitled to do that, that they put into the subpoena a false court date, and that they requested information about Luigi that violated HIPAA, and therefore, all sorts of sanctions should be attached. So today the Manhattan DA responded to that accusation. People are going to get mad at me as usual. Oh, she's pro-prosecution, which I'm not pro-prosecution. I'm just telling you like it is. You may not want to hear it. So they responded and they were like, we didn't put forth a fake subpoena, which is true. That subpoena's not fake. You can say that there were things in there that, were not okay to put in, but it's not a fake subpoena. It's a real subpoena. It just, maybe you think it shouldn't have happened and that's fine, but it's a real subpoena. That is why it was answered. Anyway, they said that the date that they put in there was totally appropriate. Now, I do agree with that it should be fine to put a date in there that's not the next court date. The problem was, which was not addressed by the Manhattan DA's office in this letter, that they called it a court date. And so that's why I said in my previous video that, probably it was some sort of typo, because the boilerplate language in those subpoenas is that they need the material by the next court date, which is fill in the blank. The fact that they didn't address that, obviously, like, they don't want to talk about it. They're probably embarrassed, or, I don't think they got caught, basically, in like a scheme to, try to get around something. I think that they messed up with the boilerplate language, not changing it, not writing, by such and such date rather than by the next court date. I think that's seriously all it was. I said that on my last video. I still think so. They didn't even bother to address it. What I would have really liked to have seen in this response was an exhibit. I just would have loved for them to have attached as Exhibit A copy of the subpoena itself. It's annoying. I actually believe, maybe I shouldn't, maybe I'm pro-prosecution, but I believe that the DA probably only requested the two things that they claim that they requested, which was, I forget, like his account number and the dates that he was covered. I think those were the two things, not his actual records. I do think they only requested that. I said that the last time, and I'll repeat it again with more confidence now, because I really can't imagine that Joel would have written in a letter to the court that that's all that they requested in the subpoena, if that's not actually true. Because at some point they're going to have to produce the subpoena, or the court has already seen the subpoena. So, to me, say what you will about me, I'm not trying to give him credit. My point is, it doesn't make sense. It's like insane if he writes that in a letter to the court when it could be so easily proven otherwise by just having the court ask to see a copy of the subpoena. Now, I wish he had just attached the subpoena as an exhibit so that we could all see it and can confirm. And it is a little weird that he didn't. Like, I will give everybody who's wary of the prosecution, I'll give you that. I think if it's so easy and black and white, I would have just included it in the exhibit itself. But he didn't. So I guess we'll see. But somebody's lying. Aetna, just to remind you, claims that the DA asked for the whole records and that's why they produced all of the records. Again, I don't think that happened, most likely, or there was some sort of misreading or misunderstanding by Aetna. We shall see, but I do think that what would really clarify things is a damn copy of this subpoena. I wish they had just put it in there. I do think also at this point, like, the judge has to either ask for that or has to ask for a hearing to kind of iron things out, because there are conflicting things. I do think that it sucks that Joel was able to get that added, like, snarky point that Karen herself produced records to the DA. Those exact same records she apparently accidentally turned over to the DA's office, which is an embarrassing snafu. And of course, he took the opportunity to make her feel, or try to make her feel bad about that by putting it in the letter and putting her on blast. So that kind of sucks. But basically, the bottom line is nothing's going to happen, okay? Like, I just think we need to, like, all understand that really nothing is going to happen with respect to the case on this. If Aetna violated his HIPAA rights or the DA violated his HIPAA rights, then there could be something done in another way, in another forum about that. Like I mentioned before, Luigi could sue Aetna for disclosing his records when they shouldn't have, or he could sue the DA's office. But like, they're not going to do anything about this case. They're not going to like dismiss the case against Luigi just because of this potential HIPAA violation, in my opinion. Before you get on me, yeah, it's bad. I said it was bad in my last video and people were like, she doesn't think it's bad. So maybe I'll just say it again. It's bad that his records got produced that way. But do I think the case is getting dismissed because of that? No, I do not. Also, it does appear that Aetna produced those records directly to the DA's office, despite the fact that they were supposed to have produced it to the court, which is another reason why I'm thinking maybe Aetna was the one at fault. So we'll see. I mean, we'll see. Again, could have been easily clarified with an exhibit, but that didn't happen. So I guess we shall see. But I wouldn't hold your breath thinking that the case is now going to get dismissed because of it.